So yeah, welcome everyone. Carly, did you want, I'm just setting up on Facebook. I don't know if you wanted to, hopefully everyone can see my screen. We just did a quick sound check for everybody and a screen check, and I believe that that's okay for everybody. So is that okay with you, Jacqui and Colin as well? You can see the screen okay?
Yeah.
Perfect, okay. Well, Carly, did you want to kick off or shall I? Or?
You can kick off, and Colin and Jacqui, you can basically be Chris Whitty today and keep saying next slide please to Olivia.
Yeah, absolutely. Well, welcome everyone. I'm Olivia from DIX. I'll say DVSA. I'm looking at a DVSA slide in front of me. Sorry, good start. DIA. No. Good start. I'm joined with our CEO Carly Brookfield and the Registrar of DVSA Jacqui Turland and Colin Drummond, who is the Fraud and Investigations Manager. Also Howard from DIA is in the background, and Tom as well, just checking things are okay. So we'll keep an eye on the chat boxes and things like that for you. So I think we've got a lot to pack into this hour, so I think we just get straight to it. I also believe that Jacqui and Colin, you're going to be taking questions after your presentation, after you've gone through your content, but we're only going to be responding mainly to the fit and proper investigation topic for today. So we understand lots of members will have loads of questions about all sorts of things, but if you're a DI member, point those to us at DIA support@driving.org, and we can help you with those. So if there's anything there that we haven't already put out there or answered for you, or you need some clarification on, we're more than happy to do that after the webinar. So today, very much focused on the fit and proper investigations, and it's actually it's a very, very interesting subject. So are you okay, Jacqui, to make a start, and I'll make the next slide?
Yes, please.
Okay, over to you. Thank you very much.
So I'm going to talk a bit about the purpose of the register, what fit and proper means, touch on the industry code of practice and the national driver and rider training standards, some statistics on the number of complaints that we get, the process of complaints and investigation, should be an S on there, and then we have 3 case studies of 3 cases that have been through Colin's investigations team, then through my team, and then through appeal. So you go to slide 3, please. So the ADI register was introduced in the 1960s, and its purpose is to protect those who are paying to learn to drive by ensuring that those teaching them have the skills which are tested through the qualification process and the standards checks, and also that they are a fit and proper person to be in close contact with their pupils, who include 17-year-old children, in some cases 16-year-old. Next slide, please. There is no definition in the Act of what is meant by fit and proper. All applicants to join the register or have their name retained in it are required to undergo an enhanced disclosure and barring service check, specifically for the role of driving instructor. This shows not only cautions and convictions, but also provides any information that police think is relevant to the role of driving instructor. So it might include words of advice following a road rage incident, or a serious sexual assault that didn't result in a prosecution. The process also checks whether or not the applicant is barred from working with children, and it is an offence for anyone who is on a barred list to apply for the role in any role in a regulated industry. And also the registrar would commit an offence by allowing somebody who is on a barred list onto the register. Many police services will also notify us if they arrest anybody who describes themselves as a driving instructor, and we liaise with police and local authority safeguarding officers when required, and also to keep up with the progress of a police investigation. As well as information from DBS for non-motoring convictions, the ADI team has access to DVLA's live database, and that allows us to verify whether or not applicants and ADIs have any motoring convictions or have accepted any fixed penalties. When we add somebody's name to the register, we provide the driver number to DVLA, and they put a marker on the ADI's record, and they then alert us to any penalty points that are added to that license. So if ADIs don't declare it, we find out anyway. Of course, all ADIs are obliged to declare any convictions or fixed penalty within 7 days, but not all do. And despite signing a declaration with every application they complete committing to do so. When making a removal decision, failing to declare a conviction or a fixed penalty, or making a false declaration on the application is always an aggravating factor in my decision. Next slide, please. The Code of Practice was written by representatives of the driver training industry, including DIA. It is voluntary and unenforceable, but it does include sound advice for personal conduct, including behaving in a professional manner, avoiding physical contact, avoiding use of inappropriate language, and not to initiate inappropriate discussions about personal relationships. Next slide, please. The National Driver and Rider Training Standards also includes guidance about creating a climate that is free from discrimination and does not exploit the learner. Next slide, please. The vast majority of ADIs are extremely professional. The proportion of complaints that we receive compared to the number on the register is very small. It is less than 3% for all types of complaints and 0.4% for serious complaints. I have no doubt that most ADIs do not have to be told that the type of behaviour that comes to our attention is in no way acceptable or appropriate for an instructor-pupil relationship. Next slide, please. So if we're talking about only serious complaints that are referred to Colin's team in the Counter Fraud and Investigations team, the first thing we do after receipt of a complaint is to make contact with the complainant to obtain a statement. Colin can provide more detail of this as we get to the case studies. We then arrange to interview the instructor and put the allegation to them. The investigator will then provide a report for the registrar to make an initial decision. And that may be to take no action, to issue a warning at that point, or to start the removal procedure. The removal procedure is laid down in the Road Traffic Act, and that requires that prior to making the decision to remove somebody's name from the register, the ADI must be informed of the intention in writing and be given the opportunity to provide their representations within 28 days. The registrar cannot make a removal decision before the 29th day. The case is then reviewed by 2 people in the fit and proper team who are part of my team, and I make the final decision based on all of the evidence, balancing any mitigating and aggravating factors. The burden of proof is on balance of probability, not beyond reasonable doubt. We're not finding people guilty. But I need to be convinced that it is more likely than not that the ADI poses a risk to learner drivers, which is the purpose of the register. Any action needs to be proportionate. Every discretionary decision that the registrar makes is subject to the right of appeal. Appeals are to the General Regulatory Chamber, GRC. They are part of the Ministry of Justice and are wholly independent of DVSA. Hearings are currently held by video conference with the judge, the appellant, and DVSA as the respondent in attendance. And although they are relatively informal, and there is no swearing in as such, it is a court, and any testimony must be truthful, otherwise one would be committing perjury. So next slide, please. So the first case study is Mr. C. So this would have started off with an investigation. So I'd like to hand over to Colin, who will talk you through what they did with the investigation.
Good morning, everybody. Thanks for joining. I'm Colin Drummond, and as the slide says, I'm the Counter Fraud Investigations Manager. My team, a team of 5, including myself, which makes it 6, we investigate all serious complaints in ADIs. I'm always asked, and it's important, how do people stay out of trouble? How you stay out of trouble is being professional at all times. Be professional. They're not your friends. It's a business relationship. Unfortunately, some ADIs don't take it that way, and they become far too casual in the relationship. So how does an investigation start? What happens? And I think it's important before we go through the case studies, we set that out so as we understand where it comes from. So as Jacqui says, what happens is someone will write into us and I'll make a complaint. I'll then be judged whether it comes to my team or not. I get the complaint, I'll review it, I'll see what there is in it, and then we'll take it forward from there. It'll be allocated to an investigator. The investigator will then make contact with the complainant, to obtain a statement. Once we've got the statement, we then progress forward. And we do a quality assurance questionnaire, and this causes some concern from some ADIs because we write out to random candidates and we ask them a series of questions. The questions are bland. They don't identify any wrongdoing. They just ask questions about how long you were with them, were you satisfied, blah, blah, blah. And then if we get a complaint from that, then we will take it forward. Why do we do that? We do it because invariably it's usually one person's word against the other. And I always say that you as an ADI are as vulnerable to the person in the car as they are to you. And that's why it's important to act professionally all the time. Once we have the statement, we'll invite the ADI in for interview. The interview's under caution. And the reason we do that, and we get asked this question all the time, is it protects you. It gives you statutory protection. And it protects the investigator. And then once we've done the interview, we will then compile a report and send it to Jacqui for Jacqui to make a decision. It's also important when people realise when we send out the questionnaires to the pupils, if there's positive comments, we reflect that in the report, and we ask ADIs if they've got positive, if they get positive reviews, they can send them to us, and we will submit them to Jacqui as well. So we don't just look for the negative; we look for the positive before we do that, and that's important that people understand. We don't always take the negative approach. If we've interviewed a witness and we're not satisfied, we write to Jacqui and we'll say, we're not satisfied with this, or whatever it may be, and then Jacqui can take a decision. We won't take it further. We've been asked in the past, why does it take so long to get an ADI to be interviewed? There's a couple of reasons. There is only 5 of us, or 6 including myself, but more importantly, we appreciate that you run a business. And what we don't want to do is put you under pressure to cancel people's tests, move their test dates, etc. So we try to give you 4 to 5 weeks notice so that you can make arrangements rather than try to get it done straight away. Some people prefer that, some people don't, and it's a balancing act for us to do that. So moving on to this investigation, as you can see, the slide says, the ADI was investigated by the police regarding indecent images in a computer. The police had an operation regarding the dark web and pornographic sites, including, unfortunately, children. And as a result of this ADI came to light. During the investigation, it was discovered he sent a very explicit indecent image to his 17-year-old pupil. He claimed that it was meant for his wife. He made all sorts of claims, which we'll get to. We then went to the police and the LADO. That's a local authority designated officer. They're the safeguarding officer. Every local authority has a statutory duty to have a safeguarding officer. And the boroughs in London all have one, depending where you are. We liaised with the police. The police then, unfortunately, had insufficient evidence on the computer for a variety of reasons. They couldn't prove it was him that had accessed and downloaded the material. We interviewed the ADI. He then said, no, actually, you know what, that was meant for my wife. It wasn't meant for me. It wasn't meant for anyone else. Blah, blah, blah. But unfortunately for him, there was a lot of comments with the image, and his timeline didn't match what he was saying. We then report the case to Jacqui, and then Jacqui took what she'll talk about later on. We get a lot of, and as you'll see a recurring theme as you go through these cases, of inappropriate text messages and inappropriate telecommunications. And I go back to what I said right at the start. It's a professional business relationship. They are not your friends. You shouldn't be sending kisses and smiley winky faces, etc., and text messages to your students. It's not appropriate. And that was it. There's a lot more to this investigation, but for the purpose of this and to make sure the person remains anonymous, that's kind of it. If you could put the next slide on for Jacqui, please.
I'm going to be a little bit less coy than Colin. Mr. C had sent his 17-year-old pupil a photograph of his erect penis. As Colin said, he claimed the image was meant for his wife and he had sent it to his pupil in error. However, earlier that day, when he had dropped his pupil off at her house, they had a conversation about her bedroom curtains, and she had mentioned that she needed a new curtain pole. The message accompanying the photograph was, "How do you like my pole?" I decided to commence removal proceedings. In his representations, sorry, next slide. In his representations, Mr. C again denied that he had intentionally sent the image to his pupil. And then on to the next slide, please. In his grounds of appeal, he explained that he had been researching curtain poles for his pupil, but he had sent the image of his penis by mistake. The appeal panel questioned Mr. C about the number of photographs on his camera roll and his stated habit of sharing explicit photographs with his wife. In his decision, the judge described Mr. C's account as lacking in credibility and dismissed the appeal. This was the first case that had gone to appeal where the registrar had removed somebody from the register solely based on a complaint rather than any conviction. So it was a bit of a landmark case. Next slide, please. And it will be over to Colin to talk about the investigation.
Okay, thank you. If you could put next slide on, please. Yeah. Okay. This was a complaint from, again, all these instructors are male who have made inappropriate comments. So the complaint was regarding inappropriate touching, sexualized conversation and using pet names for the complainer. Touching was touching the thighs and other parts of the body, and what we get some driving instructors who think it's acceptable to adjust the complainer's seatbelt and use their hand, the back of their hand, to run across their breasts. For why, I don't know. I don't know why you think that's appropriate at all, or to put their hands in their thigh and then say, yeah, we do that to encourage them to tap the clutch or press the clutch down harder. There should be no touching whatsoever unless it's for safety reasons. So the sexualized conversation, this is a recurring theme where we have driving instructors telling pupils about their sex life, asking pupils about their favourite sexual position, asking their pupils if they've ever indulged in oral, anal or vaginal sex, and if not, would they like to, and using pet names for complainers, things like all right doll, darling, and shortening their names and calling them honeys and things like that. I don't know why people think that's acceptable, but they do. We then interviewed them. We got statements from the complainant and we get text messages that the ADI sent. The ADI denied totally said that the girl had made it all up. Absolutely. We then showed him the text messages from his telephone. And then the ADI's position changed and he said, actually, I may have mixed up my phones. I've had two phones. And then what he said, which it shows you a lack of credibility, he claimed the words used may have been typographical errors along with the kisses at the end of the messages. He then claimed the complainer had mental health issues and made it all up. That's again a recurring theme where all of a sudden it's the pupil's fault. It's not my fault for being inappropriate. It's their fault and they're making it all up, despite the overwhelming evidence which suggests it isn't. We as a team understand that people do exaggerate. We understand you sometimes do get malicious complaints. Absolutely. When you're dealing with the public, that happens. But when you have evidence to show it's not that, to sternly start claiming that, shows a lack of credibility and shows that you're aware of the actions that you took. And that was that. And then we report it to Jacqui. Jacqui, next slide for Jacqui, please.
So Mr. B had clearly changed his responses when he was shown evidence from the text messages. The messages were unprofessional, using pet names and ending with kisses. I decided to commence removal proceedings. So the next slide, please. So in his representations, Mr. B claimed that he'd been confused by the investigators' questions. He maintained that the messages had been meant for his partner, not his pupil. He was confused because he had two phones. He reiterated that the complainant had made up the allegations because she was unstable. Next slide, please. In his grounds of appeal, Mr. B apologized for any offence that he had caused to the complainant, and he had meant the messages to be supportive. His appeal was dismissed. Mr. B attempted to appeal to the upper tier. This route is available only to those who can evidence a point of law that would invalidate the first hearing. It is not only if they disagree with the decision of the first court. Mr. B's point of law was that he had been in a semi-relationship with the complainant and that he had lied to both the registrar and the first tier court. He was refused permission to appeal to the upper tier. So I'll hand you back to Colin for the final case study.
Yeah, next slide, please. This one caused me a lot of concern, real concern about the ADI and his role and his other job that he had, and how he used that to coerce and bully vulnerable females into having sexual relationships with him. He was a married man. He had another job, which I won't go into, that he used to give himself some credibility, and he claimed that he would be able to find out all sorts of things about the pupils, and he used that as I suppose, a coercive control measure. And what he did was he basically coerced a young female to have sex with him and to indulge in a relationship with him, pretty much against her will. Unfortunately, when it was reported to the police, we got it and we asked the lady concerned to go to the police because we were really concerned about it. There was another 2 complainants identified. However, the police or the CPS took a decision that because of the circumstances, they were unable to prove the coercive control and behaviour, and that as such, the balance of probability, the test of prosecution may fail and convict them for rape, because that's basically what it was in one of the cases. So it came back to us, and we went and spoke to the police, and we got the statements from the ladies rather than re-interview them, because that's what we don't like to do. Just so you're aware, if the police are involved, we would prefer to get the police's statement, and we will ask them for that, and sometimes we have to pay a charge, because what we don't want to do is re-traumatise a victim by interviewing them for a second time and asking them to go through the same things, because we don't think that's fair or ethical or good practice. We will only take a statement if the police won't share it with us, or if there's something new that comes in. I met with the officer in charge of the police along with my investigator. We got the full background. The ADI was interviewed, and his position was that they all indulged, the 3 ladies were making it up, they all indulged in consensual sex with him. There was nothing untoward about it, even though he was a married man. And one was, they were friends of each other, so therefore they made this up. Absolute nonsense. We had a timeline of events from the police and also from the witnesses, which showed that not to be true. I'd made Jacqui aware right at the start of this report because I had real concerns about him. As a result of the concerns raised by myself and also by the police service, he has no longer got the second job that he had. He was removed from that because of that job, he had access to vulnerable people continually. And when I say vulnerable people, I don't mean people with learning disabilities or anything like that. I mean predominantly vulnerable females who may have had some trauma in their life. He had access to them, and we had to make sure he was taken away from that job as well, because he is a predator. Without a shadow of a doubt, he's a predator, and he used his status to select vulnerable females to abuse, for want of a better word. And then we submitted a report, and back to Jacqui, please.
So in my initial review, it was clear that Mr. M had coerced or attempted to the 3 complainants into a sexual relationship. All 3 were teenagers, and he was in his mid-30s. I decided to initiate removal proceedings. We should be on slide 22, please. Next one. Thank you. In his representations, Mr. M admitted that he had been in a sexual relationship with the original complainant, and that had started after she passed her test. He claimed that the 2 other complainants were her friends, and they were conspiring against him in retaliation for him ending that relationship. However, the messages that he had sent to all of the girls, which we had already shared with him, demonstrated that he was attempting to cultivate relationships with all 3. Next slide, please. In his grounds for appeal, Mr. M continued to maintain that it was a conspiracy, but suggested that if the complainant with whom he was in a relationship had felt so uncomfortable, she would not have continued lessons, contradicting his previous assertion that the relationship had started after he stopped teaching her. In her decision, the judge described Mr. M's actions as predatory and upheld my decision. That's it.
Okay, right. So a lot of information there. Thank you very much for going through that, both. We've got a few questions, if that's okay, to go through some of those with you now. Okay, so I'm just making sure, and Howard, can you just make sure that we're not skipping any of these, because some are in the chats and some are in the Q&A box. So, you've mentioned safeguarding and implied safeguarding from the national standards. Someone said, why doesn't DVSA make safeguarding qualification compulsory for everybody?
Well, we're not talking about safeguarding, we're talking about personal behaviour. And you know, as I said, I don't think most ADIs need to be told that these behaviours are inappropriate. It is a very small proportion of people who behave in this manner. You know, we have provided advice before that if an ADI feels there is a safeguarding need for one of their pupils, the best, DVSA are not experts in safeguarding. The best people for you to speak to are local authority designated officers. Every local authority has one. You just need to search for your local authority and you will get their details. They are the best people to provide advice for safeguarding.
Yeah.
What we're really talking about here is personal behaviour.
Yeah, I mean, obviously on that safeguarding thing, you know, there are other organisations such as us that will also help with that training as well. So, so if anyone's got any questions about that particular aspect, then come to us. Let's have a look. What else have we got? Stephen's asked, why are instructors still allowed to teach and not suspended when being removed? Why can't the code of conduct be made compulsory to sign on when joining register?
I'll answer those two the other way around. So the code of practice isn't mandatory, but then it doesn't need to be, because we always have fit and proper. The code of practice is reasonable advice. You are effectively signing up to a code of practice to be a fit and proper person at the time you apply to join the register. And there is always the risk that you will be removed from the register if you cease to be a fit and proper person. What was the first part of the question? Sorry, I forgot what to have done on the way around.
Sorry. Why are instructors still allowed to teach and not suspended when being removed?
There is a facility, a right of suspension that the registrar has, or power. That was the word I was searching for. Power of suspension, but it has to be in the most serious cases, and we have to have evidence. If I suspend somebody, and then evidence comes up that they you know, they're not guilty, so I may often suspend somebody if they are charged with a serious offence at that point. And so obviously police are involved, Colin's team not necessarily involved. If police inform us that they have charged somebody with a serious offence, and in my view that person is a risk to learner drivers, I will suspend them. If they are then found not guilty and any subsequent investigation by Colin's team doesn't give enough evidence to remove them, then DVSA is liable to pay them for all of their lost income in all the time they were suspended. So money isn't the main driver. The main driver is the risk that somebody poses to learner drivers, but it's not a decision that I can take lightly.
Absolutely. I mean, further information on that, again, it's the Approved Driving Instructor ADI Register Guide, isn't it? It's on gov.uk. Lots of information in there.
Yes.
About further information about, you know, becoming an instructor, the roles and responsibilities, registering when you are an ADI, renewing your registration, being suspended or removed, appealing decisions, and etc. So we would advise, if you haven't looked at that for a little while, then do go on there. It's on gov.uk, Approved Driving Instructor Register Guide, and it was it's yeah, good reading on there, just to refresh as well as new people coming into the industry. Essential reading for those guys as well. Okay.
Olivia, can I just make a comment here? Because I'm just seeing a comment that's come through. And I'm aware that some people are finding this session difficult to some degree. It is a very uncomfortable subject for the fraud and integrity team and the registrar to deal with, but it's their daily job in some respects. Not their daily job in terms of volume, but they are dealing with difficult cases on a regular basis. It's difficult for ADIs themselves to think about those risks and think about being in this situation. It's uncomfortable subjects to talk about, acknowledging that people aren't being squeamish about the topic. They're just, you know, alerting us to the fact that they found it uncomfortable. So sorry that we didn't necessarily put a health warning on this webinar that would be talking about, kind of intimate sexual practices and acts by ADIs. But when there is risk, we cannot avoid talking about the risk, because education is that important tool in mitigating risk. We don't want to be in the guise of enforcement or mismanagement, because that implies we've already had the risk occur, and that means somebody's been harmed. What we do through the educative seminars like this is try and mitigate risk by raising the risk that could be there for the ADI or for the pupil, educating people, because sometimes myself and Colin will sit in an interview room on opposite sides of the table, and we'll have a person sat between us who I'm representing and he's interrogating, who is affecting a complete ignorance of why they're sat there, or a complete naivety, if we're to be slightly more gentle towards the person, as to why any of their behaviors would be perceived to be, not misconduct in any way. So I wish I could say, of course, everybody in the profession is professional and they are not at risk of being in this process. But there are people who find themselves in this circumstance who never thought they would ever do that, because they don't construe their behavior as having that negative impact on a third party. So I do respect what the delegate has raised as an issue of feeling uncomfortable, feeling slightly patronized by this presentation. Our apologies, it's not our intention, any of us, to do that, but we are dealing with real risks here, and they are hard things to deal with, and somebody has been harmed in these processes, either the ADI under a false and malicious complaint, or the victim in terms of the pupil, and it is hard hitting, and we have to hit people hard sometimes to make them aware of the risks that are in the profession that we can't ignore. 3%, yes, is a very small number, but I wouldn't like people to get hung up on that, because that's the 3% that get interrogated, that are scrutinized.
No,
that come under scrutiny.
3% are all complaints, so they'll be contractual. It is less than 0.5% of those who end up being investigated. It's 0.4% of people end up in Colin's process. And I just have to add to Carly what Carly said. I'm sorry if somebody feels patronized, but I did say, when I was talking about the statistics, I do not believe that the vast majority of ADIs need to be told that these behaviors are inappropriate. Most of you are wholly professional.
Yeah.
And I would imagine that none of the people watching this anybody who's engaging in anything like this wouldn't dream of behaving in such a way. So I'm sorry somebody feels patronized by it, but these are real cases. They did happen. And if you want to find out the details, you can check the GRC's website, because the appeals cases will be there.
Can I just say something regarding this? And Carly spoke about people's behaviour and their lack of awareness. I interviewed an ADI who was an older ADI. He was in his 60s, and he'd been talking to a 17-year-old girl about sex and what she liked with her boyfriend. And that interview, I asked him, "Do you have any granddaughters?" And he said, "Yes, I do." So how would you like someone to speak to your granddaughter like that? And he said, "It wouldn't bother me." He was totally oblivious to his behaviour. Totally oblivious, because he thought that was okay. I dealt with another ADI who used a term for members of an ethnic minority. And his defence was, "They're my friends. I've got friends like that, so it's okay for me to use that. I don't see anything wrong with that." Well, actually, I see things wrong with that. So it's about lack of self-awareness as well, because some people don't understand the consequences of their actions. And that's what this is about, is understanding the consequences of your actions. I go back to what I said at the start, is the ADIs are vulnerable to the pupils. And I've spoke to Carly about this before, but the pupils are also vulnerable to you, which is why, if you understand it's a professional business relationship and treat it as such from the start, stick to the code of practice, you will never have anything to worry about. You should have nothing to worry about, because it is a professional business relationship.
And it's not just about you know, the kind of misconduct that will go to the team to be investigated. We will have pupils, because pupils do find us and pupils' parents do find us, and they think that DIA is some kind of regulator, which is highly flattering, or some kind of public complaints body as well. And we will have calls where, you know, the instructor has spoken to the pupil, not about sexual things per se, but about problems in their life, financial issues that they are facing, their religious beliefs, their beliefs in general, their attitudes to people walking past the car. And, you know, we as consumers would not like to see that behavior from other professionals that we were dealing with. We wouldn't like to see it from our GP, our teachers, and all of those. And why we held these webinars is not just to protect the public and the third parties and the pupils and everybody else. Primarily, as an organisation for ADIs, we're seeking to protect you as individuals, to make you aware of your risks and what can be done to mitigate those risks as well. So, you know, I absolutely, you know, hear what some individuals are saying, and it is a valid point to raise. It should be addressed, because if people are uncomfortable with subject matter and they don't like the way that it's delivered, then we have to find a way that's more meaningful and comfortable for them to engage in that education. But at the same time, we do need to look at these issues, because it's not just what crosses Jacqui and Colin's desk. It's everyday interaction. There can be some challenges for some individuals, a minority, as we keep stressing, but that can impact the professional reputation of the entire industry.
Carly, sorry, one other thing I should have said is that most 99% of ADIs, as Jacqui said, I've got no issues. They work hard. They're just trying to do a business. It's that small minority, and what you have to remember is that we only get some of the complaints. What we found is some of the ladies involved just change driving instructor rather than make a complaint. They just change driving instructor because you don't want to go through any hassle or any grief. And what I would encourage you as an organisation to do is, if you're aware that one of your members or one of the other driving instructors has a reputation for this, is flag it up to us, because you've got a duty and responsibility to your own organisation and to pupils. Because the only way we find things out is by people telling us, because people say, oh, you'll know about so-and-so. Why would we know if no one tells us?
Yeah. And in business terms as well, being clinical about this now, not for more serious reasons, but there is an absence in the sector of people following up with pupils post-test in terms of their performance, or people that have exited. Now, there's a lot of people that do it, but it's not widespread practice to survey customers as to their satisfaction with the product you're delivering, which is driver education, to follow up with people who have exited in a way that actually, again, going back to clinical commercial terms, a lot of businesses do that now. You know, somebody exits their business, they follow up why that person has exited. If a customer inquires about your business but doesn't follow through on that, if you're capturing the data from that customer, many companies will follow up and say, is there a reason we didn't win your business? Is there anything else we could do? And in that process, you can glean some useful understandings about the quality of your performance in general, your approach and your marketing. Is there something in that might have made the person not engage? Or if they're an existing customer and they've suddenly just disappeared, or they haven't come back to you when you've offered them products after test, why is it that they don't want to re-engage with you or continue learning with you? That's not information that's not useful. Understanding why people don't want to interact with you or take your products and services anymore is really important, because otherwise you just keep marketing yourself to new customers without realizing some of the faults in your delivery, your product, or your service, and you'll have customers going off again, and it's not good for business for that to happen. So I think in everything, customer insights are really important to any kind of business, especially one that is the product is so very personal. It's you and how you deliver that product. So try and gain those customer insights on a regular basis if you're not already doing so, because you can learn some really important things about developing your delivery and your performance as well. It's not a profession that has things like appraisals, because you're not working for somebody necessarily unless you work for a franchise or a larger group. So having that input from your pupils is like having that appraisal.
Absolutely. Jeff's asked about percentages of investigations. Which do you have any information on this, Jacqui? That's a percentage of the investigations that lead to a removal decision,
Not off the top of my head.
No, I didn't think so. No, you'd need to go away and have a little look at that. Okay, so if we, Caroline's asked, if we get a student that's come from another ADI and they state the other instructor has behaved inappropriately, can we put in a complaint in behalf of our student?
It needs to come from the pupil, because we've got to question the pupil. What they're giving us is hearsay. Sorry, I'm probably cutting across Colin's field here, but we would want to get a statement from the pupil themselves. We need to be able to question what exactly happened. You telling me that somebody else told you something is not really worth anything. It encourage them to talk to us.
Yeah, can I just reiterate what Jacqui says? We've had complaints like that where we've had ADIs report on behalf of their pupil, and what we do is we always follow up and we try to contact the pupil and explain to them, just as Jacqui said, we need a complaint from them. We don't do anonymous complaints. If someone writes in and says, Mr. or Mrs. so-and-so is a bad person, you need to do this, we wouldn't interview someone on the basis of an anonymous complaint. We'd look for supporting evidence, because you can get malicious complaints. And that's why we insist that we get statements, and we try to take other supportive evidence, which would be the question and answers that we send out to people, quality assurance, to get that. So it's important that your members understand that we just don't, someone writes in and says, so-and-so is a bad person, we don't just jump on that right away and come and interview them. There's a process we go through, because we're aware that some students will make malicious complaints. And what we do get sometimes is we get pupils that complain about their lessons and the cost, and they haven't received all their lessons. That's not a matter for us to deal with, and we tell them that's a business relationship. But what sometimes they will do is they'll say, Andy said, and it's usually him, he said something inappropriate. So we will write out to them and we say, yeah, we're really sorry to hear that. In respect of your complaint regarding the money, we don't deal with it. Please contact the following. However, if you're making a complaint about being inappropriate, absolutely, we'd like to take a statement from you. And sometimes we never hear back from them, because all they're looking for is their money back.
Yeah.
If that makes sense. So it's important that members understand we don't do this to recover money on behalf of people. We're not interested in those cases at all. Not that we're interested, it's not our role. That's a business agreement between your members and the pupil. And if the pupil tries to use inappropriate behaviour as leverage, we don't get involved in that. We keep that totally separate. So I think that's important that people understand that.
We did an article, the case studies that we do in the magazine last month, I think it was, which looked at malicious complaints and how sometimes they're triggered by financial issues, i.e. Refusal to refund, but also triggered by the pupil failing their driving test. So it's a case of, you don't help me get my license, you're not keeping yours, your ADI badge. So there's some tips in there about mitigating the risk. I mean, clearly, you know, you shouldn't have to be responsible for mitigating the risk of somebody's lack of morals to make a malicious complaint, but understanding if somebody doesn't feel that a complaint has been dealt with properly by a business. We're now in the era of citizen power, especially with social media, with people, you know, being easily able to send off an email without thinking about it to a regulator to complain about somebody. They'll send that email off that could ruin your life, your livelihood. They will take 5 seconds in their anger to send that email off. They probably won't think about it again. Job done. But it can have a long-lasting consequence for the person that's being complained about. So, you know, if you don't have a proper complaints procedure in terms of mitigating the risks to your business and to your livelihood, have a look at instituting one. And then at least also you can have a track of a complaint from somebody that could be used in evidence of a malicious complaint if it came to bear that somebody was motivated to make like a malicious complaint because they didn't feel you handled the complaint properly. And if you can match up somebody who has made a complaint to you and how they behaved in that complaints process, i.e. email exchanges, etc., you can marry that up with, you know, some of the behaviors in a malicious complaint case as well and make a case for that.
I think just from the comment from the chat, Tim has made a really interesting point. He said, my interpretation of this is more likely that some ADIs might cross the boundaries without realising. I think a likely situation is the use of text messages ending with an X, like a kiss. I think they should know it's not appropriate. They should consider the standards of communication experience from their own professional circle. Do they expect their accountant to sign it off with a kiss? So I think Tim has made a good point.
Excellent point.
Yeah, thank you, Tim, for that. Phil, if a complaint goes in favour of the ADI, are all records of the complaint deleted?
Not if it's sexual. We're required to keep any sexual allegations as part of what was the Goddard inquiry, which is child sexual abuse inquiry. We, as the regulator, we have to keep them, but they are kept in. They are kept. Their paper. They're kept under, in Wednesbury with the fit and proper team. There's no obvious record of them elsewhere, but we are, as a regulator, we are required to keep anything that is a sexual complaint.
Okay. Joe said a pupil has disclosed inappropriate contact from a previous ADI. A couple of people have said this actually. She's scared to report it, worried he will become difficult. Can a complaint be dealt with anonymously? I think we've answered that one. Sorry, apologies for that. So no, the answer is if a complaint goes in, obviously DVSA, you can't proceed with that, because anyone, like you said, Colin, anyone can say anyone is a bad person. You need some evidence behind it, and you need some substantiating evidence behind that. Okay, let's have a little look. What else have we got on here? Has DVSA ever taken action, legal action, against a car trainer of licensed drivers who is not on the register?
Yes.
Sorry, Jacqui, do you mean illegal driving instructors?
Yeah, I assume that's what they mean.
Well, you could also factor into that, I suppose, those who don't hold ADI badges but are delivering perhaps fleet training, or some of the voluntary sector of driver trainers from some of the advanced motoring brands.
In answer to the IDI, illegal driving instructor, yes, we do. We try to get the police involved because the police have got far more powers than we have. The difficulty is, and it's important your members understand this, is that unless we have evidence that person's receiving monetary or other benefits, i.e. statements, it's very hard to prove. Because if they turn around and say, if the pupil says, I've never given them any money, it just does it as a favour, and they're not paying petrol or anything like that, it's very hard to prove. And a lot of students won't give statements because they think that they've committed an offence, or alternatively, when they've passed their test, they're frightened for whatever reason. They think that we can go and revoke their licence because it wasn't a proper driving instructor that gave them a licence. So they're quite hard to prove, but we've done quite a lot of work with them, and we encourage ADIs and our test centres to look out for them, present pupils, and to get the police involved. I hope that answers that. Jacqui?
Yeah, thank you.
No, I've nothing to add.
Why are instructors still allowed to teach and not suspended when being removed? Someone knows of one harassing other instructors during that time.
I've covered that. It's got to be proportionate if I'm going to suspend somebody.
Thank you. How many appeals are upheld and how many are dismissed? I.e., does the registrar ever get it wrong?
Yes.
Brave question.
Appeals are upheld, allowed. Say GRC are wholly independent of us. They're not simply doing our bidding. The judge, the way they write it up is they stand in the shoes of the registrar and they make the decision afresh. So they look at all the evidence that I looked at, reassess it. Sometimes they have more evidence. People do go to court with things that they didn't present to me. Very often they'll say, oh, I don't want to talk about this, it's really personal. Well, that's okay, because that would have been between us. Now you've got to discuss it in open court, which is rather unfortunate and something of a waste of court time. But we do lose appeals, not many. I don't have statistics off the top of my head.
Yeah, there is that part of it where the appellant will have not brought to bear the evidence that they could have in the investigating period, and that's why when we work with members, I'm probably more frightening to some of our members in that pre-interview prep that I do with them than Colin would probably ever be in the room on the day. And members have said that I put them through the ringer far more than they actually had in the interview and in the tribunal itself. So we do ask people to disclose as much as they can to us, because that helps us prepare the case properly. And sometimes we do admittedly also expose where perhaps there hasn't been as much rigor as perhaps there should have been in some investigations. I do have to say that, because there have been a couple of cases recently where there was information there that could have been gleaned, and there were mechanisms to glean more information available as well. And that is our job as a representative body, to point to some of those challenges. Equally, it's our job to push back on members themselves sometimes about what is and what isn't an appeal. And there are times that we won't take things to appeal, or we'll leave it to the member to do, because we just don't think they're going to be successful for their own good, and we just don't think there is a case to appeal.
I think it's important that your members realise it's not a criminal trial and it's not a criminal interview that they're getting. It is a structured interview, and the investigators are limited with the scope of the investigation and the evidence they have. What I would say is that it's not a mitigating factor to claim that the person has made the complaints lying when you've got no evidence, or to say that you've heard that they've made this up with no evidence, because we go back to what Jacqui said at the start. That's hearsay. Unless you can provide statements to say that's what's happened, and unless there's anything else, then it's just your word that that's happened. And we get that in an interview where we have ADI just saying stuff for the sake of saying stuff and hoping that that's going to be okay. And the answer to that is, if you know that, why haven't you presented it? Because at the end of the day, if you have evidence, then we're happy to take that evidence. And as Carly knows, I will say to ADIs, if you have supporting testimony, please submit it. If you've something else that I'm not aware of, please submit it, because our job is to make sure the registrar gets the whole picture, not just part of the picture.
And also, if you were taking some of the steps that we recommend to mitigate risk in your daily work, kind of keeping, full and accurate pupil records, keeping full and accurate training records, cameras in car, some of the things that we recommend, then that would be able to, validate some of the counterclaims that people are lying or it was made up. And I know that ADIs that go through this process are very quick to put these safeguards in place for their business once they've been through this process. So don't wait for something to happen. Have the confidence and comfort in your everyday work that if something does happen or somebody does want to make a malicious complaint, you're able to validate that that wasn't the case. And I know it's an unfortunate world where we have to do these things, but that is where we are. So we have to safeguard the profession in that sense as well.
I'm very conscious that all of our examples were males, no female ADIs. I haven't dealt with a female ADI for sexual misconduct, but what I have dealt with is female ADIs who have bullied and acted unprofessionally in cars. That be using their phone, getting their pupils to stop while they went for coffee or shopping, still charging the pupil for that time, shouting at pupils, acting totally just being a bully in a car. And that wasn't just one female ADI. There's been more than that. And that comes back into misconduct, because it's not acceptable to bully and berate and belittle a student continually and send them text messages where you're doing that. So it's not a gender thing. With the slides that Jacqui gave, we're just showing you the wins that we took to appeal and how the appeals went. So I hope that answers some of the questions that you have regarding, did we ever get any female ADIs?
And also, we're not just talking about, traditional 17-year-old pupils here. We're also talking about ADI trainers, because PDIs will raise complaints against their trainer as well, because they are a client and pupil of that trainer. So we've dealt with, ADIs behaving inappropriately with PDIs. And PDIs equally bring in malicious complaint because they're not getting what they want out of a process, i.e., they're not passing their part 3 or something like that.
Yeah, I think we've gone through a majority of the questions. I'm just conscious of Carly, we've got a couple of slides that we need to go through.
Yeah, I'll rattle through those quickly, because let people go for 12 o'clock and lunchtime.
Sure, there you go.
Okay, so what to do if you are notified of a complaint against you, whether that's by DVSA themselves inviting you in for an interview, or a pupil has actually appraised you of the fact that they've complained against you. Contact your representative organisation immediately for a confidential discussion. If you can be pulling together any records of training or any records of your interaction with that complainant, you possibly or probably in many cases will not know who the complainant is unless they've told you directly or DVSA has disclosed. And you know, there is many a time that we go to interview and we only find out on the day. But you want, what I say to people is consider what could have happened. Sorry, Colin. Yeah.
Carla, can I come in there? And it's important that the reason we don't tell people to the day, we'll ask them to bring training notes and we'll give them dates if they need them. The reason we don't tell you the name of the pupil is because in the past, and Jacqui will confirm this, we've had ADIs turn up at people's work and their home address and berate them. So we don't want as witness intimidation, because that doesn't look good for the ADI when we then go to interview and the complainants will be on the phone and say, I've had to phone the police because this person's came to my door.
Yeah. So
that's the reason we don't tell them. No, it's not to trick anybody or make anything more difficult. It's to protect the integrity of the witness.
Yeah. So, you know, what we ask people to do is to think about, have there been scenarios where that could have led to a complaint? Have you had a pupil threaten to complain about you or slander you? Have you had a pupil that simply exited with no explanation? You never saw them again. You know, have you had somebody that you had a difficult time with? Those are all the people that you should consider. But sometimes, because sometimes we can maybe not be aware of problems we're causing for other people, you know, we might not be aware at all that we've made somebody uncomfortable, and that could be the person. And I can see sometimes the shock on somebody's face that it is that particular pupil, because they just didn't realize that the interaction they had with them has made this person uncomfortable to some degree. And whilst something might not make you uncomfortable, a 17-year-old female or young man might be uncomfortable with something, and it's their context that might have triggered the complaint. As I said, we will also want to investigate and interrogate your side of the stories. Of course, we are a representative body. You are our members. It is our job to support you, but we can't do that by saying there, everything's going to be all right. We're going to sort this out for you. We will give you a very honest evaluation of, you know, what the likely outcomes might be, what your case looks like in terms of an objective view. When we're talking about tribunals and appeals, you know, I will be very honest with people as to whether I think it's worth an appeal. And again, that will be at your discretion, and we can still represent you even if we don't agree, especially when people want to appeal the first tier result, which we sometimes have, and they want to take it to second tier, which gets even more challenging because you're actually challenging on grounds of a legal process perhaps not being carried out as it should have been. So that gets very contentious, and there's very few that have got the grounds to be appealed at the second tier. So, you know, be prepared for that interrogation. It might sound like we're not on your side when we do it. We are just trying to give a fair assessment of the scenario that we're looking at and gather all the facts together and decide whether it's worth, you know, going forward, or what the best strategy is going to be employed in your case. Next slide, please, Olivia. You will need to notify DVSA that we're representing you. I can't just ring up Colin and say, I'm coming in for interview today. He needs to know that I have the permission of the ADI to come with you. You can take a representative from your national association, or you can take a solicitor. I always caveat when we give advice from DIA that we are not qualified and regulated legal advisors. So we do in some cases recommend you take a solicitor, because that is their professional skill set and knowledge. They have the up-to-date knowledge and understanding, and they're also regulated. So there is comeback for the advice that they give if it's negligent or misleading or any of those things. And it's in your best interest to take the best person into that room with you. As I do sometimes see other associations holding out that they've got an ex-policeman who works for them, and he you know, he's the best person to take, and he's, you know, the best representative. That's not always the case in terms of up-to-date knowledge and knowing the role of being a representative in those kind of situations. As I said, we won't necessarily automatically take up every case. We do have the discretion to refuse to support in some cases. And as I said, we might refer you on to a third-party advisor that we feel is more qualified in the respect of the particular case. There are some cases that can be handled under the professional indemnity and public liability policy. I would say that is not always the case, but we will always check with the insurers as whether they're prepared to cover that. And that would mean that if they do agree to it being covered under the policy, a solicitor will automatically be supplied by the insurer from their panel as well. And generally we will support you through the process, prepare you for interview, prepare you for things post-interview, i.e. you are being removed, your license is gone, and what are you going to do next, and what are your next steps. And we stay in touch with quite a lot of people who've unfortunately gone through that process, and help them after the fact. We don't just abandon people in terms of, well, you're not an ADI anymore, so you can't be a DIA member, so we're not interested. No, we do follow up with people and try and support them, because it is a traumatic thing that happens in this process, and it is traumatic for people to lose their livelihood, even if you argue that it's through their own hand, or whether they're arguing naivety, ignorance, or whatever. But we do try and support people, because in one sense it helps us continue to educate that person before they go off into the wider world and do something else, where they might come into contact with vulnerable people or any member of the public. We want people to take those lessons forward into whatever they do next. And that's it, I think, from our side of things, unless people have got questions for DIA in particular.
Well, I'm just going to have another quick look through. No one's asked any further questions on that bit there, Carly.
I'll just skip that slide a little bit. Consider your risks. What measures should be undertaken to safeguard yourself in the course of training? What risks are there to you or your pupils in the context of fit and proper? We can't say to people it should be bloody obvious, but because we know it's not bloody obvious to people sometimes. So maybe sitting down after this session and doing what Olivia and I both love, which is a spider diagram, as I call them, where you place yourself in a circle in the center of the paper and then think about all the risks. And this is what we should be doing in an era of risk like COVID-19 and the impact that's had on the entire industry, a risk we never thought was going to happen. We should be looking at all the risks in our universe and thinking how they're going to impact us, and thinking how we will change how we deliver, how we run our businesses, what safeguards we can put in place. So specifically for this, what are the risks to you and how are you going to mitigate them? As well. And as I said, one of the first questions that Colin and his team will ask you in the process is, have you appraised yourself of the ADI code of practice? Have you signed up to that? And are you aware of the fit and proper process? Because, that is a big indicator of if you don't know how to behave, which the majority of you do, that is a template for the behaviour of the profession, along with the national standards as well. So being aware of the codes of practice, of the blueprints for how the sector should deliver, is a way of mitigating your risks in the first place as well. And as I said before, keeping pupil training records and pupil records, obviously keeping them safe. That's another safeguarding job of yours, is keeping data safe, keeping it protected, keeping it secure. And obviously we've given advice as well about data protection, but keeping good pupil records will help you not just in this scenario, but it's a good business practice to have those customer records. And you can't remember everybody and what you've done with them, but if you've got good records, you'll be able to refer back to those records when it comes to things like this as well.
Can I just say something? Most ADIs, when they come in, are well aware who's made the complaint, and they know right away before I tell them, because they understand, they know what they've done, and they know if they've had an issue with that person. So as soon as I say to them, oh yeah, I remember them, and they've got notes or they know anything, because they know. There's very few who say, I don't know her.
Yeah.
Very few.
That's true. That is true. So some of the takeaways as well as going back now and sitting and taking that time to reflect on your risks and how you can manage them, is remembering that, again, people might feel patronized by this bit, but, if we didn't see examples of this behavior, we wouldn't have to say it. So remembering that ignorance is not an excuse, be informed, be professional at all times. Again, the people on this webinar are highly unlikely, by the very fact that they are members of professional associations, that they've come onto these webinars, they're seeking to educate themselves, are highly unlikely to be this type of culprit. But, that affectation, I think we could call it sometimes, Colin, of, ignorance and naivety doesn't wash. And won't be the defense that you can make. As Colin always says, they're not your friends, they are your customers, and they are also your responsibility. You have a responsibility for safeguarding the role that you carry out, and that's an important responsibility. And this is one area where you will be held to account for that responsibility if it's not been, if it's been abdicated or compromised in any way. And all of us at all times should be self-reflecting and considering what do we need to change in what we do, in our attitudes and in our behaviours, to make sure that we are compliant with fit and proper, and also compliant with our customer expectations? Because at the end of the day, yes, the regulator is a threat in this scenario, but the bigger threat you have from having unprofessional behaviour is losing customers, losing business, and then business reputation being destroyed by those things. The customer is very much the regulator that needs to be feared, more so than Jacqui there, because they can have more of a day-to-day impact, or whether your business lives or dies.
Just I'm aware of time, we're at the hour, but just a couple of just two more questions that have come in, I think are quite important. A couple of people have asked what action DVSA will take to sort of root out unqualified instructors. Obviously, this is something which DVSA you'll be very keen to do, and I imagine you're very proactive doing that, because you need to protect the integrity of the register and all the good ADRs that are on it. So if somebody says, or you get sort of tipped off, for want of a better phrase, about somebody who is acting as an ADI, but they're not, what action would you be looking to take?
I'll answer this earlier. It's a legal driving instruction, and we do investigate it. The biggest problem we have is getting witnesses to speak, to give a statement to say they've been instructed by this person, because invariably it's word of mouth. But what we do, we try to get is the police to get involved, because if the police stop the car, they've got far more presence than we have, and they will ask a pupil, have you paid for this lesson? What I would say is that a lot of pupils, when they realise the person isn't an ADI, are furious they've paid all this money, and they will make a complaint and give a statement. So we do investigate it. There are difficulties with it, as I said, but we would encourage our members, if they know it, to report it.
Absolutely. Thank you very much. I believe that's about it for today. I'm just replying to one or two. Yeah, thank you very much, everyone. Thank you for joining us today and asking your questions, and thank you very much, Jacqui and Colin. And that's it was an informative session. It's a tough session, as you say, but informative. I think quite a lot of people have understood the reason that we've had to bring this up today, as well. So thank you for sharing the information with us. Okay, all right, everyone. I'm going to start to wrap up the session now. Is there any further bits and bobs from you, Carly, that you wanted to say?
No, just thanks for, echo your thanks to Jacqui and Colin for doing this today, and also thanks to those who tuned in and your questions on this one.
Thank you. Okay, well, everyone, stay safe. Enjoy the rest of your day if you can, and we will catch up with you again soon. Take care, everyone. Bye.
Olivia, you sent me 3 questions in. Do you want me to just reply to them in writing, because they haven't come up?
Oh my goodness.
Yeah, we'll do a Q&A after this. We discussed that, didn't we? So let's do a page of Q&As that have come out of this in terms of the key questions we've had, and we'll tackle those 3 that we had come in as well, Jacqui.
Okay.
With you.
Thank you.
All right.
For that. Thank you, Jacqui.
Okay.
Take care then, everyone. Bye-bye.